Standing in Town Square of Franklin, Tennessee, home to my office just down Main Street. The thing that Franklin shares in common with hundreds of thousands of small towns across America is that it's made up of dozens of individual businesses, small businesses, that were started by entrepreneurs, each of whom had a dream. But before they could go into business, before they could fulfill their dream, they had to decide one simple question: what type of business structure will I use? That's what we'll be talking about today on Business of Success.
One of the questions I frequently get asked when I help a client set up a business structure is, what type of business should I form? Should it be a sole proprietorship, a partnership, or some type of corporation or limited liability company? Before I can answer that question, however, it's important to understand the need for a business structure. Essentially, business entities serve as legal vessels that are used to segregate and hold various assets, things like profits, revenues, copyrights, trademarks, patents, things of value. Innovative and strategic use of various legal vessels functions as a type of shell game for the owner of the business, in which they can house and redistribute those things of value and legally shield themselves and their personal assets from liabilities and debt and reduce their tax liability. If you walk down Fulton Street in New York, you might pass a person on the street with a large cardboard box, on top of which he's placed 3 red Dixie cups, rim side down, under which he places a rubber ball. It's called the shell game, sometimes known as thimble rig or the old army game. The player will then look at the bystanders who have gathered around and call for someone to bet, challenging them that they can't locate the cup under which the ball resides after he has shuffled them. If they select the right cup, he offers to double their bets. So the bettor places the $5 on the box, and the person begins to shuffle the cups in a figure-8 pattern. After doing so, the bettor makes his choice, and the trickster then dramatically lifts the selected cup slightly on its edge to reveal to the audience around that there's no ball underneath, and the bystander loses their money. The shell game is notorious for its use by confidence tricksters, who will typically rig the game in some way, perhaps using sleight of hand to move or hide the ball from underneath the cup which was selected, and replace it there as required. Proper corporate strategy and structuring of a business entity sometimes resembles the shell game, usually the more honest version. Assets are transferred into these corporate shells to control and avoid liability and taxation. These business entities are actually creations of the law, statutes created for this very purpose. The first examples of government-created entities were the royal grants given by the kings and queens of England to individual citizens for different purposes. For example, on December 31st, 1600, the monarch granted a 15-year monopoly on trade to and from India. They granted it to the British East India Company, which in turn sold bonds to other individuals and investors in order to raise money for the operation, guaranteeing a return when they had brought the goods back from the East Indies. The British East Indies Company was the first example of a government-backed monopoly. These grants ultimately evolved into laws creating different types of business entities, the most popular of which was the first kind, the corporation. Think about the Coca-Cola Company, for example. formed in Delaware as a C Corp, it offers stock to individuals who can trade it publicly on the New York Stock Exchange. If you go to your broker and ask him to sell you one share of Coca-Cola, let's say it's $100, you are an owner of the corporation, albeit a fractional owner. Now suppose that Coca-Cola is then hit with a massive lawsuit that causes the loss of all of its assets. Are your home, car, and other personal assets at risk because of this lawsuit against Coca-Cola? The answer to that question is no. There is no legal way for the plaintiff to reach your personal assets because the corporation is treated legally as a separate entity from you personally. It is effectively a different person. So in this scenario, all you would lose is that one Benjamin that you paid for the stock certificate. Much of our current jurisprudence regarding corporate law and business structure derives from a Supreme Court case known as the Trustees of Dartmouth versus Woodward. The original charter for Dartmouth College in New Hampshire was one of those royal grants made by the British Crown. They gave the grant to the college trustees in the year 1769, years prior to the Revolutionary War. After the war, the state of New Hampshire, still a bit angry at the British for invading, seized all of the assets of the college, including the corporate records. The state attempted to force Dartmouth to become a public institution in order to reinstate a deposed president. The Board of Trustees, of course, didn't take kindly to this action, and so they sought legal action of their own in the courts. The litigation ultimately landed in the Supreme Court on appeal. In its ruling, the U.S. Supreme Court ruled that the act passed by the state of New Hampshire legislature, altering the charter of Dartmouth, which was essentially a contract, without the consent of the corporation, was unconstitutional under Article 1, Section 10 of the U.S. Constitution, which declares that no state shall make any law impairing the obligation of contracts. So that day, the court voided the state statute and instead awarded the corporation a plethora of rights that had not previously been enjoyed by the corporate structure. Corporate charters were deemed inviolable, not subject to any arbitrary amendment or abolition by state governments. Effectively, the Supreme Court gave birth to a new person, an artificial person that day, possessing both individuality and immortality. The Supreme Court case set the stage for the development of corporate structures in America in general, and specifically paved the way for the Industrial Revolution. Applying the lesson from Dartmouth that business entities are, in fact, artificial persons, separate and distinct from their business owners, we can start to draw certain implications about some of the more basic forms of business structures. And we can understand how their application may be advantageous for operating a business. There are several forms of structures that a business can take. The first is a sole proprietorship. That's created when a person decides to go into business and operate it on their own. In that case, the assets of the business and the assets of the owner are one and the same. The owner's personal assets are at risk for any liabilities or any debts incurred by the business. That's not a favorable situation for a business owner. The next type of business structure is a partnership. That's similar, except that in this case, more than one person chooses to go into business together. In the case of two partners, for example, both partner A and partner B have assets, and all of their assets are at risk for the liabilities and debts of the business. Here, either partner, partner A or partner B, can create debt or liability for the business, which can go against all of their personal assets. Again, not a favorable situation. That brings us to our third structure, which is the old faithful from Dartmouth, the corporate structure. A corporation is owned by its shareholders, who pay money to obtain a percentage ownership stake in the corporation. We call those shares. The shareholders, in turn, elect a board of directors who manage the operation of the business. They, in turn, hire officers, presidents, vice presidents, secretaries, treasurers, to operate the day-to-day affairs of the business at their instructions. The biggest difference in this type of business structure, as opposed to the sole proprietorship or partnership, is that the assets of its owners, that is, the shareholders, are not at risk from any liability or debt of the corporation, which, as we learned from Dartmouth, is a different person, an individual, separate from the shareholders. Therefore, only the corporation's assets are at risk. Finally, there is an entity called the Limited Liability Company, or the LLC. It's a sexy new animal that's only been around a few decades. It's a little less formal than the corporation, but otherwise has the same ability to shield its owners from being at risk for liabilities and debts of the corporation. Their assets are protected. Instead of a board of directors, the LLC is generally operated by its members. Look for future episodes of Business of Success in which I discuss the details of each of these structures, including the advantages and disadvantages of each. In the meantime, if you need advice on starting a business, go to barryshrum.com and set up a consultation. Thank you for listening. I'm Barry Shrum.